Welcome to Victim Advocate Privilege and Confidentiality, a product of NCVLI's Criminal Justice Training and Technical Assistance Project. This training was supported by a grant awarded by the Office on Violence Against Women, U.S. Department of Justice. The opinions, findings, conclusions, and recommendations expressed in this training are those of the authors and do not necessarily reflect the views of the U.S. Department of Justice. This video is intended to help you better understand your privacy obligations and how your obligations may differ from other victim service providers, in other organizations, or maybe even within your own office. The goal is for you to be prepared to accurately explain to victim survivors the level of privacy protection you can give to the information they share with you, so that they are empowered to make choices about sharing their personal information in the ways that are most comfortable and safe for them, and that can best meet their personal objectives. To begin, we need to understand the basic terms and concepts. Words such as privacy, confidentiality, and privilege are often used when talking about victim information, but they are not interchangeable and have very different meanings. NCVLI has a video on the topic, and the link will be given at the end of the video. In addition, you will need to understand mandatory reporting and ethics as they relate to your profession and role, your personal certifications, and your employer. All victim advocates have a professional, ethical duty to keep private communications with survivors confidential. But what does that mean? Let's use a graphic to illustrate. Many people assume that anything and everything a victim tells an advocate will remain confidential under all circumstances. This is represented by the orange circle. Everything within the circle is confidential. Notice that system-based advocates and community-based advocates are on different sides. That is because they offer different levels of confidentiality. In reality, there are exceptions to the duty of confidentiality that all advocates must understand and communicate to every survivor. Mandatory reporting obligations, Brady obligations, which are sometimes referred to as Brady disclosures or the Brady rule, and valid court orders can all affect the level of confidentiality an advocate can provide to information that has been shared with them by a victim. Thus, you can now see, as the victim information circles move outside of the zone of confidentiality based on these exceptions, the actual level of confidentiality may be quite low depending on what type of victim advocate is hearing the information. Accurately explaining to victims what information must be disclosed, when, and to whom will allow victims to make decisions about whether, when, and what information to share and with whom. Making sure that there are clear communications and expectations around privacy can help avoid the erosion of trust and other potentially harmful effects of unexpected disclosures of personal information. This video will address some of the considerations that advocates should assess when discussing the level of confidentiality they can offer a victim. We will discuss 3 considerations: mandatory reporting, Brady obligations, and court orders. Then, we will use examples to help illustrate the differences. The first question that an advocate needs to answer is, am I a mandatory reporter? Keep in mind that in some states, you only need to report child abuse, but others also require the reporting of elder abuse or abuse of other vulnerable persons. If you are a mandatory reporter, you will need to inform all of your clients that if they disclose information that falls under the mandatory reporting obligation, you are required by law to report to an official. If you are a mandatory reporter, it is always a good idea to remind survivors of this from time to time, so that it is fresh in their minds. It is okay, and is often an office policy, to interrupt a victim if you sense that they are about to disclose information about abuse, and remind them of your reporting obligations before they continue. That way, they can choose whether they want to share that information with you in that moment. Either way, it can be important to offer referrals to other victim service providers who do not have mandatory reporting obligations, so that survivors know that they have options. This means you need to know who those individuals are and understand the privacy obligations of the other organizations in your community. It should be noted that you will only share the information that has to be reported under the mandatory reporting law. Any survivor communications that do not fall within the scope of the mandatory report still have to be kept confidential, unless a separate disclosure obligation applies. Next, when determining if you must disclose other information told to you in confidence, whether you are a system-based or community-based advocate is critical. Let's take a closer look at these differences. System-based advocates are generally employed by or contracted with a government agency. Examples include advocates working for law enforcement, the prosecutor's office, and the Department of Corrections. These system-based advocates provide victims with low confidentiality guarantees because these advocates have a responsibility to the government to disclose certain information they learn regarding the offense, as well as other information if it relates to the victim's truthfulness. This obligation is often referred to as the Brady Rule and comes from a 1963 United States Supreme Court case called Brady v. Maryland. In that case, the Supreme Court held that prosecuting attorneys, who may be called prosecutors, solicitors, state's attorneys, or district attorneys, depending on the jurisdiction, are constitutionally obligated to disclose evidence favorable to an accused that is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. This means that prosecutors must automatically give certain information to defendants and their attorneys in criminal cases if that information could help their defense. Information has to be disclosed if it is important to the questions of the defendant's guilt or punishment, or to the believability of witnesses. System-based advocates need to know their organization's policy surrounding what information that they learn from victims must be turned over to the prosecutor. The Brady Rule generally does not apply to community-based advocates, or, in other words, advocates who work in nonprofit organizations and are not employed by a government agency. Community-based advocates do not have to disclose information about the crime or the victim's truthfulness to the prosecution. Both community-based and system-based victim advocates will likely receive some kind of court order, likely in the form of a subpoena or an order to compel, demanding that they turn over documents in their possession, i.e. victims' records, or to testify about the confidential communications with the victim. An advocate cannot ignore a court order. A subpoena can often be thought of as a request for a court order. It often comes directly from a party, the prosecution or the defendant, and often isn't even seen by a court first. And it can be challenged in court to determine its validity and its scope. Anyone who receives a subpoena could challenge it if they don't believe the person demanding the documents has a legal right to them, and or if the victim does not want their information shared. The court would then hear those legal arguments and rule on whether the subpoena is valid and whether the documents or some subset of the requested documents have to be turned over. The organization should immediately notify the victim if a subpoena is received so that the victim can take action as well, and also so as not to be surprised later on if the information is disclosed. Some states have a victim advocate privilege that provides greater protection for confidential victim communications made with qualifying community-based advocates working in qualifying organizations. The qualifications for the privilege vary among jurisdictions, but generally, an advocate must be certified through completing a certain number of hours of specific training, and the organization must provide specified victim services. While privileges can vary in strength, generally, if there is a privilege, no one may obtain the information without the victim's consent, even in the face of a court order. Additionally, organizations and agencies that receive federal or state funds that mandate confidentiality require time-limited, informed consent and written documentation of a victim's consent to release information before any voluntary sharing of victim information may occur. This means that system-based advocates cannot disclose victim information learned in confidence to anyone without the victim's informed, written, reasonably time-limited consent. As you've just learned, there are several questions an advocate must answer to know what level of confidentiality they can provide a victim. Let's use an example to help understand these concepts just discussed. Noah and Avery are married and have a 5-year-old child. Avery has a history of committing violence in the relationship when they consume alcohol. Avery has been sober for the past 2 years. The other night, Avery went out with friends whom they hadn't seen since Avery was in recovery. Noah was nervous that Avery may be drinking, and after a long evening of worry, took an Ambien to help get to sleep. Noah woke up at some point that night to Avery yelling and crashing around in the kitchen and living room. Noah knew that Avery was drunk, and while scared, Noah also felt the effect of Ambien and could not stay fully alert. Noah next wakes up on the couch and feels a pain in their face and side. Noah rushes upstairs to their son's bedroom to make sure he is okay and is relieved to find him sleeping peacefully. Noah has a black eye and a large red area on their side that looks like it could be a bruise. Avery is asleep, fully clothed on the bed. Noah does not specifically remember the assault, but feels certain it happened that way. Noah collects their son and heads to their mother's house and reports the assault to the police. Noah tells the police that Avery came home drunk and punched them in the face inside. Let's listen to 3 different conversations between Noah and various victim advocates and compare how they may differ. The first interview is between Noah and a law enforcement victim advocate. In other words, a system-based victim advocate. Let's listen.
Thank you for meeting with me today. I have a lot of questions that I hope you can help me with.
That's why I'm here, to help you navigate some of this process. Before we begin, I want to check in and see how you're doing. Are you safe?
I'm okay, staying with my mom, and she's a big support.
That's good. Also, I need to tell you that while I'm here to help you, I do work for the county police department. And what that means is that not everything you tell me is confidential. I'll keep what I can private, but if you talk about the incident, I will have to tell my boss, who will then report it to the prosecutor on the case, and the prosecutor may have to share that information with the defendant. Also, I'm a mandatory reporter of child abuse. If you tell me anything that makes me reasonably believe that abuse took place or is taking place, I need to inform DHS. Other than those instances, I will keep what you tell me between us, unless a court orders me to share specific pieces of information. Do you have any questions?
No.
So I know you were updated on the investigation yesterday, so let's talk about services. It sounds like you have housing for now. Do you have a safety plan in place?
No, and I don't think I need one right now.
After a physical assault like this, we like to recommend having a plan in place just in case he comes to your mom's house or tries contacting you at work.
Well, I don't think it's necessary. I know the bruises look bad, but I don't think he intended to harm me. I mean, I can't be sure, but I suspect he was just grabbing me, or I could have fallen against something.
You told the officer that he hit you.
Well, I don't actually remember what happened. I took an Ambien that evening, and it messed up my memory. I know he caused the bruises, I just don't know how. He could have pushed me down, like he did with our son that one time before he got sober. He shoved him, and he hit a table and got a cut above his eye. Something like that may have happened.
Noah, I'm sorry, but I need to tell the prosecutor that you don't remember what happened. This is definitely something that your husband could use to argue he didn't actually cause the bruising. And I need to make a mandatory report of him pushing your son. Depending on when that occurred, he might be charged with that crime too.
The second interview is between Noah and a community-based advocate who is also a mandatory reporter. Let's listen.
Thank you for meeting with me today. I have a lot of questions that I hope you can help me with.
That's why I'm here, to help you through this process. Before we begin, I want to check in and see how you're doing. Are you safe?
I'm okay, staying with my mom, and she's a big support.
That's good. Also, I need to tell you that I'm a mandatory reporter of child abuse. If you tell me anything that makes me reasonably believe that abuse took place or is taking place, I need to inform DHS. Other than that, I'll keep what you tell me between us, unless a court orders me to disclose certain information. Do you understand?
When would a court order you to disclose something?
A defendant might subpoena your records or subpoena me to testify about what you told me. However, if that happens and you do not want your information to be shared, our organization would fight the subpoena in court. We make your privacy our highest priority. We would also notify you as soon as we receive a subpoena, so you can decide if you want to get an attorney to also fight it.
Okay, I understand.
And it looks like you have housing for now. Do you have a safety plan in place?
No, and I don't think I need one right now.
After a physical assault like this, we like to recommend having a plan in place just in case he comes to your mom's house or tries contacting you at work.
Well, I don't think it's necessary. I know the bruises look bad, but I don't think he intended to harm me. I mean, I can't be sure, but I suspect he was just grabbing me, or I could have fallen against something. I told the police that he hit me, but that was just because I didn't think they would arrest him if I didn't tell them that.
You don't remember what happened?
No, I don't actually remember what happened. I took an Ambien that evening, and it messed up my memory. I know he caused the bruises. I just don't know how. He could have pushed me down like he did with our son.
Noah, I want to remind you that I'm a mandatory reporter of child abuse. If you tell me your son was abused by your husband, I will have to make a call to DHS. I would make you as much a part of that process as you want to be, but I would have to make sure that the report is made.
Okay, I think I want them to know. I want to do what's best for my son and my future. He's hurt our son before. The reason he got sober was because he shoved him, and he hit the table and got a cut above his eye. He felt so bad the next day that he gave up drinking.
I need to report that incident to DHS. Would you like to be on that call with me?
I'm not sure. He didn't hurt him this time. Do you need to tell them that I don't remember what happened? I know my son wasn't hurt this time.
No, I won't tell anyone about that night and the fact that you don't remember unless you give me permission. That's confidential. The law only requires me to share information if I need to make a mandatory report of child abuse.
The third and final interview is between Noah and another community-based victim advocate. However, this advocate is not a mandatory reporter and is also a certified victim advocate, so their communications are privileged. Let's listen.
Thank you for meeting with me today. I have a lot of questions that I hope you can help me with.
That's why I'm here, to help you through this process. Before we begin, I want to check in and see how you're doing. Are you safe?
I'm okay, staying with my mom, and she's a big support.
That's good. Please feel free to share whatever information you feel comfortable sharing with me. I will keep what you tell me between us. I'm a certified victim advocate with privilege, and that means that whatever information you share with me during our time together, I cannot disclose to anyone, not even if a court orders me to do so. If I do receive a subpoena, I will respond by asserting the privilege on your behalf. Do you understand?
When would you get a subpoena?
A defendant might subpoena your records or subpoena me to testify about what you told me. However, if that happens, I would reach out to you and ask me if you wanted me to share that information. If not, then our lawyer would tell the court that you have not given us permission and that the law prevents us from turning over the information. We make your privacy our highest priority. You could also get your own attorney to help keep the information private.
Okay, I understand.
It sounds like you have housing for now. Do you have a safety plan in place?
No, and I don't think I need one right now.
After a physical assault like this, we like to recommend having a plan in place just in case he comes to your mom's house or tries contacting you at work.
Well, I don't think it's necessary. I know the bruises look bad, but I don't think he intended to harm me. I mean, I can't be sure, but I suspect he was just grabbing me or I could have fallen against something. I told the police that he hit me, but that was just because I didn't think they would arrest him if I didn't tell them that.
You don't remember what happened?
No, I don't actually remember what happened. I took an Ambien that evening and it messed up my memory. I know he caused the bruises, I just don't know how. He could have pushed me down like he did with our son.
He abused your son in the past?
Yes, he's hurt our son before. The reason he got sober was because he shoved him and he hit the table and got a cut above his eye. He felt so bad the next day that he gave up drinking. I don't want to get him in trouble for that. I just want him to get help and then be a good father to our son. Do you need to tell anyone about the abuse?
No, not unless you decide you want to report the incident to DHS, and I can help you with that if you do decide to report the abuse.
I'm not sure. He didn't hurt him this time. Do you need to tell them that I don't remember what happened? I know my son wasn't hurt this time.
I will not tell anyone about that night and the fact that you don't remember or his past abuse of your son unless you give me permission. That is all confidential.
From these examples, you can see that victims will encounter advocates who can offer different levels of privacy protection to the information shared with them. It is important to know your level of confidentiality and privilege so that you can accurately inform victim survivors of what you are able to keep private. This will help maintain a trusting and successful relationship. To learn more about privacy, confidentiality, and privilege, visit www.ncvli.org and the many resources available.